Well, hi everyone. Thank you so much for joining us despite this crazy weather. We've had over 150 folks register for this webinar. And we're amazed. The TCEQ wastewater permitting process is probably not the most riveting topic for a conversation, but it couldn't be more important for the future of our waterways. My name is Marisa Bruno. I'm the Water Program Manager at the Hill Country Alliance, and we're co-hosting this webinar with Barton Creek Association, represented today by Advocacy Director Brian Zapchik, and the Greater Edwards Aquifer Alliance, represented by Executive Director Annalisa Peace and Technical Director Nathan Glavey. All of our organizations work in the Hill Country, which, as I think most of you know, is experiencing rapid population growth. More people means more wastewater, and we care about that. Because in the Hill Country, we have more miles of pristine streams than any other region in Texas. These pristine streams often have spring-fed, crystal clear waters, and this is key, extremely low levels of naturally occurring phosphorus. Treated wastewater often contains nutrients, including phosphorus, that can act like a fertilizer, causing out-of-control algal blooms and impacting the health of pristine stream systems. And many of these streams are recharge features for the Edwards and Trinity aquifers, meaning that wastewater not treated to drinking water standards is discharged into these streams where it goes directly into the aquifers, potentially polluting our potable water supplies. All three of our organizations work alongside community members who are impacted by new wastewater permits. This webinar is not being hosted in response to any wastewater permit in particular, and we will not be commenting on any particular permits. But we do have a goal of hosting a webinar to empower community members to follow and engage with wastewater permit applications to ensure the best outcomes for their communities, whatever that might be. For this webinar, we could not have dreamed up a better presenter. Lauren Ice is an environmental lawyer who has counseled many Hill Country residents on the wastewater permitting process, and we're so grateful she is joining us today for this webinar. In fact, it was her birthday yesterday. So everyone, I guess, send her some warm virtual wishes. Before I hand this off to Lauren, I just want to say a few things about the technology. If any of you have not been on a Zoom webinar before, it's a bit different from a standard Zoom meeting. The main difference is that there's a Q&A feature. So if you have any questions as you're going through Lauren's presentation, please put them in the Q&A. We'll be monitoring that, and if we can answer them directly, we will. And if not, at the end, during the Q&A session, we'll pass those questions along to Lauren. This webinar is being recorded, and we will also be sharing out the slides at the end for all of you who've registered as a resource. Okay, I'm done talking now. With all this said, it's my pleasure to pass the mic to Lauren for the presentation.
Great, thanks, Marissa. And I hope my power stays on for the duration of this webinar. As Marissa said, my name is Lauren Ice. I'm an attorney with the firm Paralis, Allman & Ice. We are based in Austin, but we work all over the state, and we're a public interest environmental law firm, which means we only represent plaintiffs or protestants in environmental matters. We never represent industry or applicants who are trying to defend their pollution or in an attempt to get a permit to pollute, which I think is important in the context of today's webinar, because as Marissa said, this webinar is really focused on navigating the TCEQ's wastewater permitting process from the public's perspective. And as she said, understanding that the process by which our state issues these permits is very complicated for the public to understand, could go into a variety of reasons for that. But this is true even if this is, if this is something you're somewhat familiar with, if you've gone through this process before. I think it's still very complicated for the community to feel like they're really taking advantage of all their opportunities to fully participate. But especially if this is your first time going through a permitting process, it's really not very intuitive. And so I'm hoping that today's webinar will sort of help lay that out in a more clear manner. I should also clarify at the outset that what I'm about to provide, even though I am a lawyer, is not legal advice. This is meant to be a guide. So if you do have concerns about a specific matter, I would encourage you to reach out to a lawyer for advice on that specific case. I'm assuming that folks can see the slides that are up. Is that true?
Annalise is just sharing the screen right now. Yep.
Okay, there we are. So Annalisa, if you would advance to the slide that's titled Why Participate. So presumably folks who are watching this webinar are, as Marissa said, interested in learning how to participate in the permitting process. And I am going to walk through that process together, talk about sort of the deadlines that you definitely don't want to miss, that sort of thing. But first, I want to back up and talk about why participate at all. Why not just leave this decision up to the agency and to the applicant? And to be clear, I think it's something we should all start with, a foundation we should all start with, which is wastewater permits are permits to pollute. They limit pollution in certain ways, but very simply, there is just not a wastewater permit that is not going to have some kind of impact on the natural environment. And if you live or recreate near a wastewater treatment plant, those impacts are going to be on you and the way that you use and enjoy that place. So as Marissa said earlier, streams and rivers in the Texas Hill Country are especially susceptible and are impacted much more severely by the addition of wastewater effluent. This is a photo of a picture of the South Fork San Gabriel River downstream from the City of Liberty Hills wastewater treatment plant. This was taken by a member of the public who's been documenting impacts of the city's wastewater effluent on that particular river segment for years. And this algae growth is occurring where the city has a TCEQ permit. And so it's no wonder that so many folks in the Hill Country are concerned about wastewater, even subject to the requirements that are in a TCEQ permit. So maybe you're here today, you're concerned about these impacts coming to a stream near you, but you don't feel like you know enough to weigh in. So the first thing I would tell everyone is to remember that this process, this public participation process, is your right. What we're talking about is a process that exists for the public to participate in. It's for laypersons, not anybody who's a wastewater expert, to express their concerns, to ask questions, to challenge decisions that they don't necessarily believe are right. So don't hesitate to get involved because you're not a wastewater expert. Second, public participation really does improve the permitting process. More attention a particular permit gets from the public means more attention from everyone else, including the TCEQ commissioners, the staff who are writing that permit, and even the applicant. The agency deals with a lot of permits, and only a very few amount of those actually receive comments or are challenged. And so you can imagine if they're dealing with a lot of permits, if someone calls their attention to one, they're going to pay closer attention to that permit. And finally, of course, the reason you should participate is because it's possible to win real improvements for the environment and for your community by participation. And we're going to talk about some of those near the end of the webinar, but often those kinds of improvements are only a result of public participation. They wouldn't be achievable any other way. So with that, I think I want to talk about the types of permits that we're talking about. Next slide. So this webinar is going to be focused on municipal domestic wastewater permits. So think sewage. There's other types of wastewater permits that are issued by TCEQ, such as industrial wastewater permits or stormwater permits. This is not about those kinds of permits. There's also permits that are required for on-site sewage facilities, or what we normally call septic systems. TCEQ has jurisdiction over those, but again, that's a different permitting process. So to be clear, the process we're talking about today is really with regard to municipal domestic wastewater permits that'd be necessary when you're thinking of a big housing development, or there's another situation where there's a large amount of sewage in one development, like maybe a summer camp. So generally speaking, there are two main types of permits that an applicant can choose from. You see option 1 and option 2 here on the slide. The first option is a discharge permit, and the second option is a land application permit. The discharge permit will authorize the permit holder to discharge wastewater effluent directly into a stream, a river, a lake, another kind of surface water body. And these are issued under the Texas Pollutant Discharge Elimination System permit. So they're often called a TPDES permit or a TPDES permit. That's what I call them. And I know these acronyms can be frustrating and they're not really common sense, but I'm going to use a lot of acronyms today because they are frequently used throughout this process. And if you're interested in participating in the process, you should at least have a basic idea of what some of these acronyms stand for. The second option is a land application permit, and this is called a Texas Land Application Permit, or a TLAP. And these permits allow for surface or subsurface disposal of effluent on land, and they require the permit holder to have a certain amount of land available that they have committed just for the disposal of the wastewater. Now, TLAPs have their problems, to be sure, from an environmental perspective, particularly if the land is close to a waterway, or maybe the land contains cracks or fissures or other conduits to groundwater below. But generally, the kinds of clients we represent would much more prefer having the effluent being irrigated rather than being discharged directly into the waterway. The other thing that's mentioned on this slide is what's called reclaimed water, or what a lot of people call Chapter 210 reuse. Reuse is not strictly a disposal method, so an applicant has to have one of these other two disposal methods before they're eligible for a 210 reuse authorization. But reuse comes up a lot in the course of these conversations, especially in the Hill Country, where we're trying to do everything we can to keep wastewater out of our surface waters. And we'll talk a little bit more about how that works into the permitting process later, but I just want you all to be aware of that and thinking about that as we go through the next steps. Next slide, please. So the last piece of sort of foundational information I want you all to have before we dive into the process are the kind of the key players in the permitting process. There are undoubtedly a lot of more people involved than just these folks, but this is my general overview based on who I see the public interacting with the most. So first you've got the applicant, of course, the applicant who's submitting the application to get the permit. With domestic wastewater, your applicants are usually either going to be a city or maybe another governmental entity like a municipal utility district or a water control and improvement district, or they're going to be a private developer who's maybe proposing a large residential development or a summer camp, like I said earlier. Understanding who the applicant is important because it's going to help you understand who's going to own and operate that facility and who's going to be responsible for following the rules. It's also going to give you a little bit of an insight into what their interests may be. The second group of key players are the protestants. I use the word protestants generally to refer to the public who are commenting on a permit application or who may be eventually protesting that permit application. So these are usually landowners, neighbors, maybe community organizations or nonprofit groups, but they can also be other cities. They can also be some other kinds of governmental organizations, so keep that in mind. And then the third group of key players is the Texas Commission on Environmental Quality. And this is our state agency, often referred to as the TCEQ, that is issuing the permits that we're talking about. TCEQ is a large agency, so I've included some of the different offices here within the TCEQ that the public often interacts with. It's overseen by 3 commissioners who are appointed by the governor. They are ultimately the ones responsible for issuing permits that are contested. The chief clerk's office maintains all the records, the public notices, filings that are related to permit matters and helps to track their status. And so this office is always going to be a good source of information for the public. The executive director, which is also called the ED for short, oversees the agency's staff. So the people in the office who are processing the application and writing the permit terms, they are in the ED's division, and the staff. So the staff is often referred to as the ED, and the ED is often referred to as the staff. The ED can issue permits that are uncontested, whereas contested permits have to go to the commissioners. If a permit's not contested, then that permit can be issued by the ED. And then finally at the TCEQ is the Office of Public Interest Counsel, or OPIC. This office was specifically created to represent the public interest at large. So it is a group of attorneys. When items are considered by the commissioners, the ED will give their position to the commissioners. That's the position of the staff. And then OPIC will present a position that is from the public interest at large. So while they can't represent any one of you individually as an attorney, they are very helpful to the public in understanding sort of the rules, the legal process, and they have the public interest at large interests in mind. So we'll talk more about them later. And then the final sort of group of key players is those at the State Office of Administrative Hearings, or what we call SOA for short. SOA is an administrative agency. It's completely separate from the TCEQ, but they use administrative law judges, or ALJs, to hold administrative hearings to help resolve disputes that involve Texas agencies. So in addition to environmental matters, they hear a whole host of other types of agency matters, licensing, utilities, that sort of thing. But they are a completely separate agency, so their ALJs are neutral. Some of them have experience in environmental matters and some of them do not. Next slide. Okay, so we've gone through a lot of acronyms. I'm sorry for that. But now I want to look at the steps we're going to walk through. I've boiled down what I think is a pretty complex process into 10 basic steps. So this is maybe an oversimplification, but I think this is what is sort of most important for the public to pay attention to. And this, this little graph here is something we're going to use, or this timeline is something we're going to use on each slide as we walk through the steps so that you can easily follow along as to where we are in the process. So generally speaking, of course, this process starts when the applicant submits their application. There's two required notices, a first notice and a second notice, which are public notices we're going to talk about. There is a deadline by which the public needs to submit their comments to be considered. There is a response to the comments that the ED will issue. There is a deadline to then request a contested case hearing. We'll talk more about that for sure. And then there is a time for the commissioners to consider those hearing requests and decide whether or not they're going to grant a hearing. And then if they do, that goes to SOA, who will hold a preliminary hearing, and then eventually a hearing on the merits that will culminate in what's called a proposal for decision from the SOA administrative law judge. And that proposal for decision is the final step here. We'll go back to the commissioners to consider. And it's only at that point, after the applicant submits their application, if it is contested by a member of the public, that they may or may not, depending on the commissioner's decision, get their final permit. And it's not until they get their final permit that they can start construction and start operating using that permit. So there's a few extra steps thrown in here, depending on the situation. We are going to talk about these steps in detail, and we're also going to discuss some potential outcomes if you go to a hearing, or other outcomes if you perhaps successfully negotiate a settlement. Okay, next slide. Okay, so let's get started with step one. Step one, as I said, the applicant submits their application. That starts this whole process. The ED, or the staff, is going to begin what's called administrative review of the application. And that means they look to see if all the pieces and pertinent information are just simply there. If not, they can issue what are called notices of deficiency, or NODs, because we like acronyms for everything. The applicant has a certain amount of time to respond to these NODs. They have to respond specifically to each one. And I bring this up because sometimes these NODs provide useful information for the public. If you were to ask for these, if you were to get these NODs, it might tell you what the TCEQ is paying close attention to, or what they might think is deficient in the applicant's application. And that might highlight the places where you feel like there might be some problems. So if you're asking for application materials, which we'll talk about how to do that, you should also be asking for NODs, and you can also ask for the applicant's response to those NODs. I'll mention just this new item that's been required as of November 2022. There's a new component in applications called a public involvement plan. And it's my understanding that this is really a requirement that was added because some groups, some environmental groups, very credibly, in my opinion, alleged that the TCEQ was not complying with Title VI of the Civil Rights Act. And that's when we talk about environmental justice, that's essentially where that comes from. So the TCEQs attempted to implement this environmental justice consideration into their application materials. It's kind of too soon for me to have seen this play out, but I'm flagging this for those of you who may be in communities of color, low-income communities, and or what we call environmental justice communities, that there might be an additional level of involvement that's now required. Okay, next slide. Oh, first notice. Okay, so once the administrative review is done and the staff have said we have all the pieces of the application, then the ED issues the first public notice. And this is called the NORI, or the Notice of Receipt of Application and Intent to Obtain a Permit. Again, sorry for the really long title and the weird acronym, but this is what's going to appear on the top of that notice. So if you know that this is a NORI, that will help you determine sort of what stage the application is in. So the applicant has to publish the notice in a newspaper. That's a widely circulated newspaper in your county, or maybe in your city if we're in the city limits. Sometimes bilingual notice will be required. Then the chief clerk will mail this notice to landowners who own land adjacent to the applicant's land. And in the case of discharge permits, they'll also mail notice to landowners who are 1 mile downstream on either side of that waterway. And for TLAPs, they'll mail notice to those landowners who are 1 mile from the facility as the crow flies. So the applicant has to, as soon as the NORI goes out, they have to make sure that the full application is available for viewing and copying somewhere in your county, and they have to indicate where that is in this notice. It has to be, it's usually a place like a library or somewhere where access is not unreasonably restricted to the public. And they also have to include in there their own contact information. So if you have any questions, you can reach out to them directly. This is also the first time you'll see the permit number being assigned, and that's going to start with the letters WQ for water quality, because these are water quality permits. And that means the comment period is now open. So if you submit comments, you'll want to include that permit number, or if you're doing it online, you can search by that permit number, and that'll make sure that your comments are assigned to this particular application. So it's a permit number, even though there's no permit, there's no draft permit, there's certainly no permit, but that they start with the permit number to make it easy to track the specific application. Okay, next slide. So I was talking a lot about how to get information, and we are asked a lot where to find this information. There are a lot of ways, there's more than one way, but this slide includes several of the ways that I frequently find this information. The first is the Commissioner's Integrated Database, which is a database of filings that are maintained by the Office of the Chief Clerk. They're about all kinds of pending permitting and enforcement matters. So if you have a permit number, you can search by the permit number, but you can also search by your county. You can search by the applicant's name if you happen to know who it is, or a whole host of other fields. You can actually even search based off of people that you know might have commented. You can search by commenters' names. You could go search yourself and see what applications you've commented on, which brings up a good point that some of the public may not be aware of, which is that your name and your address and your email address, if you've commented on one of these applications before, that's going to be public information, as is your comment. So just keep that in mind as you submit those comments. But like I said, we use this a lot. This database also includes a lot of relevant deadlines, so it's pretty comprehensive. We also use the central registry a lot. If you know who the regulated entity is, so if you think about the facility, that actual facility is the regulated entity, you can use the central registry to look up the affiliated customer. So for example, if your wastewater treatment plant is being built by a city, you could look up the customer would be the city, and then you could go up and look and see how many other wastewater treatment plants that customer operates, which would all have their own regulated entity number. And that's useful because also in the same database is information regarding whether any of those entities have received public complaints about their operations in the past, whether any of them have had enforcement matters lodged against them. And so it's generally their compliance history, which of course, if you're dealing with a brand new facility, sometimes that's something you want to know. The third thing I've listed here is a public notice database. It's just exactly what it sounds like. It's a place you can look up public notices. So it's a little more limited, but if you know what you're looking for, it's a good place to find that specific notice. Same with the wastewater permit status check. That's another database that's limited just to wastewater permits. So if you know what you're looking for, it's a good place to just try to find that information. If you can't find, and these are good tools if you're up late one night, maybe obsessing over an application you just learned about, so you can look on your own time and kind of your own schedule. But if you still can't find what you're looking for, you can also just contact the TCEQ wastewater permitting staff directly, and they've got an email address and a phone number to do that. You can ask them questions, and they're pretty responsive in my experience. You can also contact OPIC directly, the Office of Public Interest Counsel, especially if you have questions about where you are in the process and what you can do, and how the process works going forward. And then finally, a tool I'll mention that our office uses a lot is just a good old-fashioned public information request. So TCEQ is a state agency. It's subject to the Texas Public Information Act, which means, generally speaking, all the application materials are going to be public, and all the communications between the applicant and the agency are going to be public. So the TCEQ accepts requests via email. That email address is included here. That's fairly convenient. You should just be aware that it's normal for it to take a couple of weeks for you to get the information that you're asking for. So build in time to allow for that. And depending on how much information you ask for, how thorough that is, they may assess a fee for the time spent compiling that information. But often if you're just asking for the permit file, it'll be free. So that's a good way to just cover your bases and make sure you're seeing everything you think you should be seeing. Okay, next slide. All right, so returning to our timeline, after the NORI is issued, that's the notice that the application is administratively complete, the staff will conduct their technical review of the application. So now they're looking to see whether the application actually complies with the agency's rules and requirements. And again, the staff can issue more NODs to the applicant, technical NODs, and it would be this time. And the applicant might have to provide more information. And just depending on how complete or incomplete their application is, this process could take a few months. It could take much, much longer than that. But if the staff determines that the application does eventually meet all of their requirements, then technical review is complete and they will prepare the draft permit. And so it's at that time that the public will receive notice of this decision. And this is the second notice that's called the NAPD, or the Notice of Application and Preliminary Decision and Draft Permit. So again, the applicant has to publish this in a local newspaper. Again, the chief clerk will mail this notice to adjacent landowners and downstream landowners. Though this time, even more people will get notice. If you've joined the mailing list, then you should also get notice of this. And just as with the first notice, the applicant has to make sure that the materials are all available for viewing and copying somewhere locally. And this includes any revisions that they would have made in response to those NODs. It also includes the draft permit at this point. So it is important to emphasize that they have prepared a draft permit at this stage, but it is only a draft. It is not final. The applicant cannot begin building or operating yet. The draft permit essentially means that the staff have said, based off of the application, they determine that a permit issued to the applicant, if it were written in this way, it would meet the rules and requirements of the agency. So it's important to emphasize that the application itself is also a part of the draft permit. So as we move forward, people are going to talk a lot about the draft permit, whether it complies with the rules and regulations. But we're talking about all of these things, the application materials included. So the NAPD is a very important notice because it is what determines the final public comment deadline. So comments have been open this whole time, maybe for many, many months, but this is what says you now have 30 days to provide any of your comments, and we're cutting them off after 30 days. Technically, it's from when the NAPD is published, because it will be, as I said, it will be published, but it can be difficult to determine when that is. So you might need to call the chief clerk to get an exact date, but it definitely won't be less than 30 days. Next slide. Okay, so step 4 is the public comment deadline. This is, as you can imagine, a very important deadline. We'll talk more about it later, but essentially If you're concerned about a project and you want to hear what you want the staff to consider those concerns and you want to hear what they think of those concerns, you want to get your comments in by the deadline. They can consider comments submitted afterwards, but they don't have to. If you're concerned about anything that you think might be related to the wastewater permit, you're going to want to put that in your comments. We'll talk about a contested case hearing later, but whatever you might want to pursue in a hearing, you're going to have to raise in your comments. They do not need to be things that you know for certain for 100% will occur. They can be things that you are just simply concerned about at that point. They can also be in the form of a question if you want the ED to provide you an answer to your question. And you can submit as many sets of comments during the comment period as you want. So if you submitted comments a year ago, a lot of time went by, things changed, definitely feel free to submit more comments. Just be as thorough and specific as you can be. You'll also want to make sure that the right people are submitting comments. And I mean this to say there are no wrong people to submit comments. Everyone can submit comments. But what I mean is that everybody who wants to participate should submit a comment. Don't think that your comments, somebody else can piggyback off of your comments, or you could submit comments for your entire family. Maybe you have like a family ranch and property was all subdivided and left to the children. Well, if you own one piece of property, don't think that your comments will automatically apply to the rest of the property, even though it's, you know, a big family ranch. You just can't adopt comments by others unless you actually copy and paste them and put them in your own comments and submit them as your own. So be cognizant of that, and we'll talk about why that's important in a minute. You also want to start thinking at this stage, well, before this stage, you want to start thinking about whether an organization should be the one to submit comments. A lot of our clients like to either form a new organization in response to a permit application that they plan to oppose, or they like to join with an existing organization who might be planning to oppose it. And that's just because, you know, you can submit your own individual comments and it's good to do that. But if you also submit comments on behalf of an organization, that organization has the ability to pursue the issues you raise in your comments. And it can be a long, daunting process. And a lot of times people don't want to be solely responsible for going through that. And a lot of times communities like to organize together, you know, especially share legal fees that might be involved to protest a permit together when it's something that's going to benefit the whole community. So if you want an organization to be protesting, you'll want to submit those comments on behalf of the organization as well. And so this is the deadline. So I would just encourage folks that once you start learning about this, start thinking about if you're going to have an organization, submit those comments. Think about that earlier. Don't wait until the last comment deadline to do that. Forming an organization is really a lot easier than most people think. We help clients do it all the time. But as I said, there's also groups who are on this, who help sponsor this webinar. Greater Edwards Aquifer Alliance, I know, has served as like a fiscal agent for new groups. And so there's ways to collaborate with groups that do this kind of work regularly. I'll just briefly mention that there are several ways to submit comments. The easiest for most people is going to be online, and I've included that link here, just because once you submit it, you're going to get an immediate response in your email that says your comments were submitted successfully, and that gives a lot of people peace of mind. But you can also submit them in the mail in writing. You can submit them in person and you can fax them. Just be aware that if you submit them in writing, they really need to arrive by the deadline, and the deadline is going to be a 5 o'clock deadline at TCEQ. So there's little things like that you want to be aware of to make sure your comments get in on time. So take a look at that, that page there on commenting. It includes all that information. Do that before the last day of the comment deadline so you know how you're going to get your comments in on time. Okay, next slide. All right, I'm going to try to speed things up a little bit here. This is what I'll call a bonus step. It's a public meeting. It is held by the TCEQ, but it's not something that you necessarily have a right to. It's something that's only held if the ED determines there's a significant amount of community interest or if a legislator requests it. So my advice is always to ask a legislator to request it because they have to host it if the legislator asks for one. So go to your legislator early, tell them there's a lot of interest in this application, assuming that's true, and you want them to ask for a public meeting. It's a really easy thing for a legislator to ask for because it doesn't commit them to take a position on the permit application. It's just asking them to give their constituents an opportunity to have a meeting and weigh in. The applicant, the ED, and OPIC will all attend the meeting. After they do sort of a brief round of introductions, there's always two main parts to a public meeting. The first is going to be your informal question and answer session, and the second is going to be a formal comment period. So at the beginning, the first part, you'll be able to ask questions of anyone who's there. They will provide answers. They may not be the answers you want, and they may not be satisfactory, but they will respond to your questions. But those are not a part of the public record, so they will not go into the official public comments that the ED has to respond to. The second part of the meeting is the formal comment period. So they will take these comments that are made orally, they will take note of them and they'll put them in the public record, but no one will respond to you at the meeting. And so you'll hear a lot of people say that, or talk about like strategy and how to use this, because, you know, sometimes people will spend a lot of time in Q&A and maybe you don't have as much time for formal comments as you like, or maybe people will leave the meeting before you get to the formal comment period. So it's something to think about. A lot of folks use this as an opportunity to invite media, you know, invite their legislators and really get a lot of public attention to a permit application that might have a lot of public opposition. Usually these have been remote over COVID, but usually they're in person. And when they're in person, they're going to be held somewhere near where the facility is proposed. So maybe like a school gymnasium or a public event center, so that folks in the community don't have to travel too far and you can all show up together. And it's a great thing for people to show up and listen to other people speak, because you really do get a good sense of sort of what are the concerns and the issues. And I always tell clients that sometimes this is the only time that TCEQ staff gets out of the office and actually comes to the community where the facility is being proposed. So use your comments as an opportunity to really paint a picture for them and let them know what it's like there, because they might just be seeing it on their desktop and that's it up to that point. Okay, next slide. So after the public, I should have mentioned, so the public meeting will automatically extend the deadline to submit comments to the end of that meeting. And you can submit written comments at the meeting as well if you want to jot something down on the back of a napkin while you're there. 60 days or more, often more, depending on how many public comments are received, the ED will issue their response to the comments. And so they typically will group those comments based on subject matter. So if, you know, 20 people kind of submit the same thing about odors, they will group them together and then issue a response to the comments about odors. The other thing that the response to comments will do is at the very end, explain if they've made any changes to the draft permit. So I have seen frequently actually changes that are made based off of comments that people make during the comment period. And so that's where to look for that. The response to comments also triggers, and response to comments will be mailed out to everybody who's made a comment or everybody who's on that notice list. But that also triggers a very important deadline, and that is the deadline by which to request a contested case hearing. So next slide. So a contested case hearing is, oops, that slide got a little wonky, but a contested case hearing is like a civil trial. I'll tell you more about it in a minute. But what you are doing when you ask for a requested case hearing, when you request a contested case hearing, is you're submitting it in the same way you submitted your comments. You know, you can do it online, you can do it in person, you can mail it in. But you want to reiterate all the issues you raised in your comments that you might want to raise in the hearing. So anything you don't want, you know, to be off the table. So I always tell people, put everything in there just in case. It doesn't mean you have to litigate it. It just means you can. And then you want to describe how you are going to be impacted, how you believe you'll be impacted in a way that's different from the general public. So the TCEQ commissioners, I don't agree with this analysis, but the analysis that they use is property ownership and proximity to the facility. So they'll typically say, if you own property and you use that property, excuse me, and you live, you know, within a mile or downstream a mile, that property is in that proximity, then, and you can explain how you're going to be adversely affected. So if you're going to be affected by the odors, or you think you're going to be affected by the algae growth and your ability to swim, if you think the odors are going to make it hard for you to sit outside and watch wildlife or garden, any of those kinds of ways you use your property that you think is going to be impacted, those are the kinds of things you're going to talk about and the way that you're adversely impacted that's different from just the general public who says, I want to protect the environment all over the state of Texas. So at this point, if no requests for a contested case hearing are received at any point during the comment period, then the executive director can issue that permit uncontested to the applicant. But if there is even one hearing request, then the decision of whether to hold a hearing has to go all the way up to the TCEQ commissioners, and they have regular agenda meetings, and they will consider the hearing requests at their regular agenda meetings, and you'll receive notice of that. You can also file what's called a request for reconsideration. Usually people file this with their contested case hearing request, and it's simply saying, hey, I think the ED got it wrong. I'm asking the commissioners to review the ED's decision. I very rarely, if at all, ever see those granted. So I just mentioned it so you know about it. Okay, next slide. So the commissioners will consider the hearing request. They'll have a meeting and they will refer the decision to whether to grant the hearing. If they grant the hearing, they'll refer the matter to the State Office of Administrative Hearings. So this meeting is something you'll get notice of. You can watch it online or you can attend it in person, but you'll know right away, usually the day of the commissioners meeting, whether or not they're going to grant your hearing request. There's an opportunity to sort of file a reply. So if the applicant or the ED or the OPIC take the position that your hearing request shouldn't be granted, you should be on the lookout for that, because you can file a reply and say, oh, maybe they got something wrong, and make the argument for why it should be granted. Next slide. Okay, so if the TCEQ commissioners grant a hearing or grant at least one hearing, then they'll send the case over to the State Office of Administrative Hearings. They will hold a preliminary hearing. This is the initial hearing to name the parties formally and to set a procedural schedule that'll cover the whole hearing on the merits for the next 4 months or so. This is how you know that you will not accidentally get into a contested case hearing without meaning to. And so when I say, if you want to request a hearing, you can always change your mind later. You have to go to the preliminary hearing in order to be named a party. You will get notice of this hearing at least 30 days in advance of the hearing and where it'll be held. And so you'll have to be very intentional about showing up. Even if your hearing request is granted by the commissioners, you still want to show up at this preliminary hearing and say, yes, I want to participate in this hearing. Okay, next slide. So as I said, the SOA hearing is really like a bench trial, meaning it's just a judge. We don't have a jury, but we do have expert witnesses and fact witnesses, opportunity to do discovery and different opportunities for legal arguments. It'll last about 3 to 4 months after the preliminary hearing, at which point we'll have a hearing on the merits, and that's where we get live testimony from usually the expert witnesses and sometimes the fact witnesses. It's after that hearing on the merits that we file closing arguments, and those closing arguments are what we're asking our judge to decide. The judge will then take about 60 days after closing arguments, and they will issue their proposal for decision, or PFD. And that is, it's very important for everyone to understand, a recommendation back to the TCEQ commissioners as to whether or not to deny the permit, grant the permit, or maybe grant the permit with certain conditions. So next slide. And so that decision has to go back to the commissioners. They will consider it again at one of their agenda meetings, which are available online, or you can attend in person. They'll usually make that decision the very same day to adopt, reject, or modify that PFD. And so even if you get a really good PFD recommending a denial of the permit or a permit with really strong conditions, a lot of times it's very possible that commissioners may still grant the permit anyway, or they may find other conditions that they don't like or conditions they want to add. They'll have to issue their decision in writing. There is an opportunity to appeal that decision to district court. The problem with that, or the challenge with that, is that it's very difficult to get an agency decision overturned at district court. So I say all this just so you know where you're headed. But the process from start to finish, when an application is submitted until you get through to that commissioner's decision at the end, can take often 2 years, sometimes even more. And so the applicant does not have their permit until they get all the way through that process, if this is something that's contested. Okay, next slide. So at any stage of the process, the parties can agree to settle the case. And parties might want to settle for a variety of reasons, but I just want to point out that TCEQ and SOA both have free mediators available. So if you're not represented by counsel, or if you feel like you can't talk to the applicant or their attorney, the mediators can be your intermediary. They can go between and help you with those conversations. You can also hire a private mediator if you want to pay for one. Some people do. I'll say on our timeline, a common time for settlement to occur, if it's going to occur, is often right before the preliminary hearing or shortly thereafter, because that's kind of when the applicant knows who is likely to go to hearing. And it's also, it's before a lot of resources on litigation have been expended. So the more you commit to litigation and the further you get down that track, just obviously the more difficult it's going to be to resolve the issues ahead of time. And I will say that based on my experience, a lot of contested wastewater permits settle without the need to go to hearing. And that's because there are some pretty creative things that that protestants have been able to ask for, the applicants have given them in settlement. And those are, things that everybody I think should consider. So next slide. So these are just some examples of in cases where I've seen settlement occur. These are the kinds of things that settlement has achieved. So it's important for folks to remember, if you go through the hearing process, what you can get out of that is either the permit's denied, which is challenging as we talked about, it's granted just the same way that the draft permit was granted, or it's granted with conditions. And those are conditions that the TCEQ is going to be willing to put in a permit. So it's only things that go to that water quality permit. When you're in settlement discussions, nothing is off the table. So you can talk about things that are not related directly maybe to the wastewater permit, but are related to the development at large. So things that I've seen, here's a list of those. We've seen people through community organizing and advocacy just convince the applicant to withdraw their permit, or maybe withdraw their permit and apply for a discharge permit and then apply for a land application permit instead. We've also seen a reduction in total permitted flow. So maybe instead of 250,000 gallons a day, you're getting an agreement to only discharge 150,000 gallons a day. We've seen commitments to reuse a certain volume of that water, or to even enhance their treatment standards, so they're discharging, cleaner water. And we've also frequently seen good neighbor provisions that mitigate the impacts of the facility itself, like the aesthetics, the noise, the odor. We've also seen protestants get money for mitigation efforts they want to put on their own property. And then, as I mentioned, if you're looking outside of just the permit itself, when you have like a big development, maybe we've seen applicants agree to increase or to decrease the impacts of that related development. So like reduce the density of their development, maybe include development buffers between existing neighbors, or implement more water conservation, or road access, limit road access to the neighboring properties, things like that might be important to your community. And commonly we see better monitoring, more frequent monitoring, and more transparency and reporting to the community. So next slide. Next slide. Okay. So here's just a few quick tips I'll leave you with. I know we're running short. Just remember through the process that this is your right to participate. So if you ever feel like you're being a burden or you're gumming up the works, good. This is your right to make your voice heard in this process, and it is written in the statute. So take advantage of it. Talk to somebody early in the process who has experience. I would recommend that you talk to a lawyer, because it is complicated, even for folks who have been involved in many of these. But the folks who are hosting this webinar, GIA and SPCA and Hill Country Alliance, they've got a different perspective too from the community organizing angle. Pay attention to the timeline for the community input, because as we said, you can inadvertently or accidentally waive something that you don't want to waive in the future. So you don't want to waive your right to a contested case hearing. You're not committing yourself to a hearing until you get to that preliminary hearing and you say, I want to move forward with the contested case hearing. You won't accidentally commit yourself, but you don't want to give up that leverage or that ability to pursue that hearing if you want to. And as I mentioned, community organizing is really effective. It proceeds sort of parallel to this legal tract, and it's just so valuable in so many ways. So and a lot of times these permits are like the first time a community gets organized and they are empowered and they work together, and it really does play a big role in defeating the application or getting improvements for the community. And then finally, I'll just say, be thinking about other permits that the applicant might need. If they need groundwater permits or they need surface water rights or any other kinds of approvals from other agencies, you don't want to be blindsided by those. There also might be an opportunity to leverage, your ability to participate in other permitting processes. So think about that. Next slide. All right, now I'm done and available to take questions.
Lauren, thank you so much for that. For the attendees on this call, we're 5 minutes away from the end. So I'm only going to pose to Lauren a couple of questions, but if you post your questions in the Q&A, we'll make sure to send them to Lauren and respond via email. So I want to ask a question that was asked early on about the sort of notice that folks get. So can you confirm adjacent landowners, they're going to get a copy of the NORI and NAPD via mail, or is there a process to get on that list?
You will get a notice via mail, and it's going to be, I think, like typically they're going to use the appraisal district's information. So if you need to update your whatever your contact information is, and then you can get on a list. The last time I tried to get on a list for the TCEQ, it's not easy to get on a list that is proactive. So before an application is submitted and you know about it, if you get on a list, they're just going to be sending you all kinds of applications and notices. So normally folks don't find out until the NORI has been issued, but you might call the chief clerk and see if there's a way to get, if you have something in mind, the chief clerk would be the one to call and see about getting on a notice list ahead of time.
So that's related to another question. Someone shared that Senator Eckhart is requesting a public meeting. And so someone asked, is there a way to get notified of if that public meeting goes through and when and where that meeting is? Do you have to be calling TCEQ, or is there some sort of notification system you can sign up for?
So you can put yourself on the mailing list. So if you don't want to submit a comment, but you want to just be added to the list, you can just submit a comment that you want to be added to the mailing list, and then you will get notice of everything that's filed in that case. So you would get the public meeting notice. But if you know that a senator has requested the meeting, it will happen, and you can confirm that with the chief clerk, but you don't have to wonder if they're going to grant the hearing, the public meeting or not. It will happen.
Okay, great. I'll just ask one last question then, and like I said, the rest we'll answer via email. There's a question about the new public involvement plan. Can you just talk a little bit more about that and who is required to have a PIP?
I don't actually know a whole lot about that, so because it is brand new, but there is a form. It's only going to be for new permit applications or major amendments, and it's a form, I think, that is intended to identify whether or not this facility is located in an environmental justice area, and if so, whether or not enhanced public participation is required. So I haven't actually seen anyone submit one yet, but that'll be interesting to follow. Personal opinion, that's not nearly enough, what they need to be doing to comply with Title VI, but it's a start.
Awesome. Well, thank you so much, Lauren. That was an amazing presentation. That was definitely a very long process, but I'm glad that we got to talk through all of the steps. And if this was a normal Zoom meeting, I would just ask everyone to join me in an applause. Thank you. I do want to, oh, sorry. Yeah.
Oh, I was going to say, I put my email and phone number on the screen. So if folks have specific questions, they're welcome to reach out to me individually.
Awesome. Yeah. And Elisa, would you mind just resharing that? PowerPoint one last time. Then we can put Lauren's info up. Yeah. So it's Lauren's information. We'll be sharing that out right after this webinar. And I also want to just quickly talk to some resources that GIA, SBCA, and HCA have to offer on the topic. Next slide. All right, Annalisa and Nathan.
Hi, yeah, and if y'all, we have been doing this for a long time, so it's probably way too much information. But if you go to the GIA website, we have a wastewater page. So if you you go to the library, it's resources library, and then you'll see the wastewater page. There's actually 2 pages on that. You can see you know, articles about different cases. Our comments are always on there, but also negotiated settlement. So you can look and see what other cases have negotiated. And so, you know, people find that that's a really helpful thing. And then we do, we've done so many of these cases. And so we welcome your calls and we can help you out usually.
Brian.
Hey all, Brian Zabchik from Barton Creek Association, where I'm the advocacy director. We also too provide coordination for the No Dumping Sewage Coalition, which has been around for since 2017. Several organizations, including GIA and Hill Country Alliance, are members of that coalition. We also too function as the wastewater subcommittee for the Texas Hill Country Conservation Network. The reason I'm telling you all this is that NDS meets monthly every second Wednesday at 10 a.m. on Zoom, which means that our next meeting will be exactly 1 week from today. If you send me an email to the email that you see on the screen, Brian at savebartoncreek.org, I'll be happy to add you to our email list. If you just want to be added for informational purposes, that's fine. But we work on all of these issues and more dealing with wastewater on an ongoing basis. Thanks.
Great. And then I'll just do a little plug. Hill Country Alliance does a lot of work supporting local grassroots groups that are working on these issues. And twice a year, we have a gathering for these folks. So if you're working on anything related to wastewater in your community or other water issues and want to join our next grassroots gathering, please send me an email. Yeah, and with that, that wraps it up with just a minute over time. Again, thank you all for joining. Thank you, Lauren. Thanks, Annalisa, Nathan, Brian, from everyone.